My name is Christopher Ralph. I'm the legal administrator for Health Law Services in Jacksonville, Florida. We specialize in the medical necessity defense that I guess we'll be getting into a little bit. So we're just glad to be here. And to Mr. Quigley and Mr. D'Angelo, we just want to say thank you for allowing us to speak and be part of the event.
Hey, good morning. My name is Sean Gearhart. I'm an attorney with the Reisman Law Group, and basically what we're doing is helping businesses who want to get involved in the medical marijuana industry incorporate under the laws of Florida, work with you with licensing, and then with compliance after the fact. What my intention is to try to build lasting relationships with people that want to get involved in this industry. All right.
Get the old golf clap over there. Get the golf clap. Attorney Dominic Ferriello, law office is Dominic O. Ferriello, PA. I have an office in Tampa. I do predominantly criminal defense, personal injury, traffic law. I have a show on 102.5 The Bone, which is on the FM dial, called Ask the Dom, where folks will call and I would give out free legal advice. I've been doing radio about 8 years. I've had my own show on the weekends now for about a year. I spoke along with Sean a few months ago at this event when it was in Tampa. And we encourage all of your questions because a lot of us, although we look like attorneys, we got fancy suits, we don't know necessarily what the hell is going to happen, which is why we're here to answer your questions and basically give advice that the best that we can, although we still have to wait for this law to pass, which we believe it would, but that won't happen until November. And I'll yield to the lovely Miss Lily.
My name is Lily McCarty. I'm also a criminal defense attorney. My practice is about 95% state of Florida criminal defense. I've done some federal work. However, Dominic, and I work in the same building as Dominic. He asked me to come along if there was any questions that were specific to criminal defense in Florida.
And she's awesome.
She's your attorney, right?
She's my attorney. If I get in trouble, Lily represents me, so that's how good she is. Sorry, you.
My name is Ian Christensen. I'm an attorney with Health Law Services. I specialize in healthcare compliance and medical marijuana laws in the state of Florida.
Why is it so important if you're going to start any business? Why is it so important to have legal representation? What type of legal representation would you need, and how is that different in the cannabis industry? And I'll direct that question at Mr. Dominic first, and then possibly Sean.
Well, as I said in the seminar in Tampa, you want to know what county you're in. You're going to need to know law enforcement. You're going to need to know attorney based in that county. You're going to need to know elected officials and representatives in that county. Because each county, in my humble opinion, is different. I know there was a reference to Polk. You go from county to county, although we're in the state of Florida, it's like going to it's a different jurisdiction. Some counties are conservative. Some counties are liberal, and some counties don't know what they are because they may not be educated on this issue. That was a very good presentation, very informative and educational. And unfortunately, outside of this room, there's a lot of officials in law enforcement that don't know a lot about what we just learned throughout today and the event as it goes on through the weekend. So when you think of attorneys, and I don't know how many of you in this room are specifically have the medical necessity, or if the majority of you in this room are more or less entrepreneurs, that you want to be growers and harvesters and then sell it. So you're looking at two different distinctions here as far as where do you classify yourself as. So first you want to think of when you wake up in the morning, and I know I scared a lot of people in Tampa when I said this, the first thing in your mind when you wake up in the morning is, am I going to jail today? And I think that's a realistic thought to have. There's nothing wrong about thinking about that because you are protecting yourself, your family, and your business. Because as it stands as an issue, it's against the law federally. But now when the law passes, and I know we were talking about in between now and then is where your presentation fell in, but assuming for the moment that we get to November, you first want to have an attorney beforehand, and why I'm glad Sean is here, is to explain the legal setup of the business aspect of it. Because what's going to happen with this industry is it's a moneymaker, right? And there is going to be an issue with banks taking the money. And I don't want to get into that. That's more your arena. So it's more of a cash business. So you really need to get with a lawyer first and foremost to set up the structure financially and the business plan. Myself, Lily, we're more on the back end, God forbid, if there are charges that come down by nature of us being criminal defense attorneys. Now, if you want to hire a criminal defense attorney and put one on a retainer, you can. But I'm based out of Hillsborough. Sometimes I go to Pasco, sometimes I'm in Pinellas. I know Lily goes to a lot more counties than I. But if you're in a different part of the state, don't hire us, in my opinion. Hire someone locally. The local attorneys will know the judges, the prosecutors, the law enforcement personnel, local representatives, local politicians, etc. It's a lot easier from that standpoint. So when you go through that mental process of, well, I don't want to be arrested today, and I'm taking the steps to protect myself legally, it starts with that. And I'll yield, if I may, to Sean about the business and the banking and the finances, because that's not me.
Yeah,
Absolutely.
you know, one of the things Steve talked about earlier is the risk analysis. And whenever you're starting any kind of business venture, one of the questions I think you should ask is whether the juice is worth the squeeze or not. You know, because especially in this business, where you still have the issue of this being a Schedule I drug federally, you're going to run into legal issues. And if you don't want to run into those, that's going to be the first analysis that you're going to want to do is, am I going to get arrested? Well, if you don't want to get arrested, you may not want to get into this business right now because it's still illegal federally. However, and I know some other people have talked about this, the U.S. House of Representatives did vote to defund the Department of Justice for investigating properly licensed medical marijuana businesses. That still has to pass the Senate, still has to be signed into law. But right now, depending on where you are in the state, U.S. attorneys can still investigate and still arrest people. So now, getting away from that, if you do want to get into this business, it is imperative that it's set up properly from the start. You want to set up the business, you want to have proper documentation, so a proper business plan, so when you do apply for the license, you have everything in order. We don't know what those rules are going to be yet. We can look to what's happened in other states and kind of get an idea. There's going to be residency requirements. There's going to be capital requirements. We don't know exactly what those are going to be yet. But you want to be ready for it when it comes. And I think you can set up a business today to get ready for that. I also want to yield to Dominic as well. I'm in Pinellas County. We had a meeting last week. We talked to the mayor. They're not making any decisions on whether they're going to allow dispensaries in the city of St. Pete until the amendment passes. Orange County may be different. If you live in Orange County, you should get a business lawyer that's going to be doing business in this area of the law, and don't call me. Now, you need to get somebody that's going to be local, that's going to represent you, that can do the best job for you in this industry.
I think that Pinellas and Pasco are more conservative by nature, in my opinion. Hillsborough tends to be a little liberal, the Tampa Bay area. But then Orange County, in my opinion, is much more liberal relating to DUIs across the state in an example of a criminal charge. And I don't know necessarily why that is. It's just that you have to understand the venue to the point where you have those three elements that a police officer may or may not know as far as whether the qualifications of a medical necessity. I've had law enforcement on my show from detectives, deputies, police officers. In March, I had the chief of police for the city of Tampa, Chief Castor, a very nice lady, on my show. I don't know if the officers will know whether or not at the time of your contact with them, this information. I think they will arrest you based on the information at hand, and then they'll let the courts sort it out. So now by default, you have to do what? You got to hire a criminal defense attorney. You got to freak out a little bit because the criminal defense attorney is going to educate you on, well, is it a misdemeanor? Is it a felony? Do you have a prior record? If you do, that comes into play. If it's a felony, there's a score sheet. And now you got all this stuff flying around in your head. So that although it's great to talk about these laws, the way it happens is a process. And then you get to a state attorney, and if the state attorney assigned to the case is not familiar with it, now you're at a supervisor level, and it goes on from there. Lily, am I right with this as a defense aspect? I mean, you do the criminal stuff with me.
Well, I agree that it just comes down to human interaction and human error, and it also comes down to how the officer that you deal with is interpreting the documents and what the law is at the time. And I think that it also it comes down to, I tell my clients all the time, law isn't always black and white. There's a lot of gray in the area, and it's how the court's interpreting what the law is. It's how the officer that's at the scene that's interpreting. It's how the interaction goes with the officer. It's how you deal with the situation. It's how you confront the situation. There's no right. There's no right or wrong answer. There's no yes or no. So every circumstance and every situation is different.
Absolutely.
I think that the best thing that someone can do for themselves in a circumstance is to keep their cool, not to get upset, not to get frustrated, even if it seems that that's the natural reaction to do, and to make sure that you contact an attorney as soon as possible, because the other circumstance that you're in is maybe that there is something that's not validating what you believe is correct. Well, then here you are saying, yes, this is mine, and I'm using it for medical purposes, and you're admitting to possessing something that's an illegal substance. So there are a lot of things that you have to consider, and you should probably talk to a defense attorney and a business lawyer beforehand. An attorney is going to advise you on what the law is. They're not going to tell you how to get around the law. They're going to say, this is what the law is, this is the state of the law, this is where you would fall within the law, and this is what I must tell you it could happen if you do this.
And if I can quickly comment on that, you are absolutely correct when you said when a law enforcement officer approaches somebody or there's any type of contact, it's not what you say, it's how you say it. If you talk to a law enforcement officer and throw this in their face that, yes, I have a right, get out of my house, and just act in bad faith with that officer, they are naturally going to become confrontational. By simply asserting the rights and having documentation, which at the top of this documentation outlines what bad faith means for an officer, what the consequences are for acting in bad faith, for violating human rights, and making sure that they have a statement from a licensed physician in the state of Florida. If they pursue any further, they are then violating a human right based on the case law. It's very important. We do not want anybody going out lighting something up saying, yep, because I have a prescription for Oxycontin, I can do this. They're going to tell you, here's some bracelets, tell it to the judge. The key to this defense, as Mr. Bill Wolsifer has reviewed these pleadings and he's agreed, the key to this defense is not getting arrested in the first place. If you can prove that you are not violating a law and an officer has the information in front of them, law enforcement drives around, when they drive around, they have case law books with them. If they see that there is an exception in the law enforcement officers do not want to violate somebody's rights. They want to make sure a crime is not being committed. And that's exactly what we were referring to.
And I also want to say, though, that yes, I understand what you're saying. The concern that I have, though, is what if you have an officer that doesn't understand? What if you have an officer that's confused? What if you have an officer that's not educated? What if you have an officer that does not even know that there's changes?
That's that's what the purpose of the documentation is to inform that officer. And so there is risk involved, and even with this defense that the officer may not believe your defense is authentic, but I mean their belief has to be done in good faith, and if there's no reason to believe that your documents aren't authentic or that something wasn't forged or whatnot, then there is no reason to make an arrest. And like Chris said, we've spoken to several law enforcement officers. We've spoken with elected sheriffs. They are all in agreement that this is the law in Florida, and if somebody had these documents ahead of time, that they would not make an arrest, provided that they the documents were correct and authentic, and they established those elements.
Right.
I mean, I'm not trying to disagree, and I'm not trying to be the criminal defense pessimist. The concern that I have also, and I'll give an example of what I have happen a lot that I represent a lot of people for, is prescribed medication, where they have a prescription. It's a controlled substance, whether it be an opiate or it be a benzodiazepam or benzo. They have a prescription for it. They have a bottle of 100 pills. They don't want to go on vacation with 100 pills. So they buy a pill pack or they buy something and they put a controlled substance in something that's not labeled. And here they are, maybe they're not in their county, maybe they are in their county, they get pulled over, they have a controlled substance without a pill bottle, without something, and they go to jail. And now that doesn't mean that the charge doesn't get dropped. It doesn't mean that the attorney doesn't fight and file motions for the case to get dismissed, but they still have been booked in jail and they've still gone through the humiliation. So why I'm saying all this is that I think that there's going to be a lot of kinks in the road, as we all understand. And why I'm saying this is that this is probably why it's best to talk to an attorney throughout the process, because this is not going to be an infallible system, and it's not going to be an end-all, be-all, and there's going to be bumps along the road that everyone needs to learn how to deal with.
Absolutely. No, absolutely. And that's why we recommend talk to an attorney. Don't just go see a doctor and think you're okay. You have to have this documentation from an attorney. We allow 24/7 access to our firm, so and we even provide an identification card for somebody. Of course, it says it's not government-issued ID, but it's an ID card with the phone number, the 24-hour number to our law firm. If they call our law firm, we will be able to verify all of the information that's provided. And one thing I did want to comment on. Ignorance of the law is no excuse for a citizen to violate the law, correct? Ignorance of the law is no excuse for an officer to violate the law. We have to remember that. Officers have no further authority than what is outlined in their scope of practice or their scope of work. They have to abide by the same laws we have to abide by. Ignorance of the law is no excuse? Touché. That's what we say to them. Now, that again, as you were saying, of course, we have to be proactive with this, and that's why we've spent a year working quietly behind the scenes, working with these politicians, working with law enforcement, and they understand all of this. But will we have a rogue police officer that will go after somebody, or will somebody forget their documentation and they're going to say, tell it to the judge? Absolutely. No different than, as you were saying, Xanax or any other prescription. If you put it in another bottle, you legally have a right to use it, but you are outside of the scope of what the requirements are for you to use it, because you have to have that labeling with you at all times. Same thing with cannabis. You have to have this with you at all times, no questions asked. If you are found without it, you'll be able to do it in court. It'll have to go through the state attorney, intake, everybody else, and eventually it'll be dropped. But the way to do that is to not bring your prescriptions without your prescription bottle. You do not take your cannabis without all of the documentation. And that's very, very important, because there are going to be bumps in the road with this. Absolutely. We also understand that this is a stopgap measure. It is not an end-all, be-all. There are no regulations. But in the state of Colorado, there was a court case, Jason Love versus Colorado. Mr. Love was found not guilty of cultivation of cannabis. He was a paraplegic. When he smoked cannabis, he was no longer a paraplegic. He was able to get up and walk because it reduced the inflammation in his spinal column. Okay? They found him not guilty. August 5th of 2009, which is a case law, common law jurisdiction. My clinic was open and operating August 6th, 2009. They knew that they could not do anything because it was a big splash in the papers that the case law says you cannot do this. That's all we need, is to have everybody stand up and say, we are not going to have our rights violated any longer. That's what it takes, awareness. Somebody who is using cannabis for medical purposes is not the criminal. It is the law enforcement officer who does not know what the law is, who is violating somebody's right. That is why they can be stripped of their immunity. That's why we have statute 768.28, because law enforcement officers do get arrested, and they also act as criminals just like anybody else does. So that's what we have to remember. It's very important, but we have to be diligent. It's very important to be diligent with all of this and have an attorney available to you at all times. Very important.
I think this nice lady has a question right here.
As you're recommending to everyone that they go out and hire a lawyer, which I really applaud, I wondered if you had any guidance for us, since there doesn't appear to be a board certification program. And, you know, of course, a few lawyers here and there might be unscrupulous and take their money and not know a damn thing about what they're advising people. So do you have any guidance on that?
Yes, I do. Since we have vetted this information, again, Mr. Bill Wolsifer, who's running for Attorney General, I would consider him pretty qualified and having knowledge of current laws. He has written a public statement regarding our approach to this. He completely agrees with it, and he states that this is the 21st century jurisprudence. Being proactive and asserting the fact that you are not engaging in criminal activity is very important. When you are arrested, of course, you are innocent until proven guilty, but we all know that judges are prejudicial. They're going to see you coming in handcuffs. It's a mental sign you're a criminal. If you take the approach with law enforcement, even if you get pulled over because you just picked up a half an ounce of dry cannabis for neuropathic pain, for example, when that law enforcement officer pulls you over, you tell him you have cannabis in your vehicle. You provide him all the documentation. If you look like you're hiding something, if you look like you are trying to avoid something, you're trying to, pull something out of your hat to try to get you out of trouble, they're going to have suspicion.
Let me interrupt for a second. With all due respect, I don't know if that was the answer to the lady's question. If you want some guidance, each county in the state of Florida has a bar association. Each bar association predominantly will have a lawyer referral service. So you can contact Manatee County, Orange County Bar Association. You have a referral service. And in the referral service, you can ask for a lawyer in the specialty for which you seek. If you want a business lawyer for this venture, a criminal defense lawyer, a tax lawyer, if you're getting audited. I think Tom mentioned that he was audited by the IRS. So that is, I think, a better answer for your question for seeking guidance. Does that help better?
Just to be clear, I'm asking, how do we know that the lawyers that we're hiring have any experience in the cannabis?
Well, that's what you ask the attorney when you meet with them. When you speak with an attorney, ask them, what is your background? Have you experienced, do you know the laws? Do you know the rules? And the other option is, if you have time, and I know a lot of people don't, but if you have time, go to the courthouse and watch them in court. See how they do. I'm just saying, if you have the time to, but also, you ask them the background, ask in the community, and you're shaking your head no, because apparently you're not.
Yeah.
The establishment of a business, running a business.
Okay.
And that's what I focus on. Is there anybody besides you in the whole state that really has been focusing on this?
On medical marijuana business? I don't know. But you can take the approach right now. Any business attorney can set up a business. Okay, because right now you're not going to be in the medical marijuana business. And that's all I'm doing right now. For folks over in Pinellas County, I am setting up Florida nonprofit businesses. I'm getting all the organizational documents put together. I'm putting together a business plan. And that's all that we can do at this point until the amendment passes. And then we can start applying for the licenses, however they're going to distribute those, and then work with them to ensure that they're complying with whatever the regulations are. Now, I just asked Dom, I didn't know this beforehand. Dom offers free consultations. I offer a free consultation. I think the best way to get to know somebody, go into their office and talk to them, and see how you feel. My goal in this, and I'm very passionate about this. My father was in Vietnam. He was exposed to Agent Orange. He's had several different kinds of cancers. He will not use cannabis because it's not legal. Okay? What I am trying to do is establish long-term relationships with folks. I'm not trying to buy a Maserati. And I know that you've probably heard that from a lot of different attorneys. I went to law school because I felt that I could help people. And this business in this area of the law right now is the best way that I know how I can help people. And that's why I'm doing this.
Yeah, he does
So-
not have a Maserati. I think he
don't.
takes public transportation.
Yeah.
My friend.
Yeah,
I see
PSTA.
my friend on the bus. That's the lawyer I want. Yes, ma'am.
I have two questions. I found that you're going to be needing to be a patient to own a dispensary or cultivate or bake or anything like that. But to have a license, if you get arrested and you have a felony arrest, you can't get the licensure to own something. So what I'm thinking here, you guys, is like, if we did what you said, and I get arrested, would I lose my chances of having a licensure or become a patient or own a dispensary because I tried to get it now? That was what I did.
Well, we don't know exactly what the regulations are going to be for Amendment 2. We know that it forces the health department to create rules and the legislature to create all of the legal regulations along the lines. I did have the privilege of working with Senator Romer and helping co-author House Bill 1284. One thing I can tell you when that happens is the bill that ends up being voted on is not the bill that the people want in the beginning. I can assure you of that. If that were not the case, I'd still be in Colorado right now.
But what I was trying to say is, if I'm arrested and I'm a patient, I'm doing the process, and I have to talk about legalization, would that be a felony, and would that take me out of it to be a patient or?
Right. If you have all of your documentation, and again, this comes from the state attorney's office, and as Mr. Robert Jordan can attest, he was not arrested when this happened. When he had his documentation, he was not charged with a crime. Now, if you are charged with a crime, it is only because you are acting outside of the scope of what the elements are required for somebody to meet. If you are acting outside of that scope and you're charged with a crime, we don't know what the law is here in Florida, but based on Colorado law, then yes, you would no longer be allowed to operate in that industry. They most likely will have similar regulations here, which is why we say it's so important to cover all of your bases as much as possible to make sure of this, and also have
let me
the
ask
outreach.
let me ask you a question, because you said, because you in Colorado, because her question is, if you get arrested in Colorado, even the arrest, then you can't operate the business. Okay, because that to me, because I don't that's not Florida.
That's the conviction, not an arrest.
Yeah, okay, well, the conviction, that's the distinction. I don't think she knows that. If you're arrested for anything, you have due process to challenge the arrest. And that process may take several months or a year or longer. It's until you would be convicted, God forbid, of a felony, then you'd be a convicted felon, which a lot of folks here, if you have prior felonies, but you want to get into this business, now you have to entertain a notion of sealment or an expungement process. So I think that while you were arrested, I could be arrested for 20 things. Doesn't mean that Dominic did anything wrong. That's just contact with law enforcement. Now, if I'm convicted, which hopefully Lily will get me out of trouble, is a different thing. So do you understand the difference between arrested and conviction? Of general contracting, okay, I understand.
Regardless if I'm arrested or convicted, they can still take my license away from me, and I can't take that chance.
Right.
Even though I'm
And if you look, there are going to be certain enumerated felonies that if you've been convicted of, you're not going to be able to get a license to be in the medical marijuana industry. And from what I understand and from what I've heard from different state legislatures is that if you've been convicted of a drug felony, forget it. So yes, if for some reason you did get convicted of a drug felony, I would say that would probably take you out of the running of getting a license in the medical marijuana industry.
And it's also interesting to know that in Colorado, they did put that into House Bill 1284 that has created these regulations regarding a felony. It was not if you were charged, it's only if you're convicted. But there is an exemption in 1284 that if the felony or misdemeanor conviction was for simple possession of cannabis, that is not a disqualifier. Now, if it's for heroin, cocaine, of course, that's a different issue. Any crimes of dishonesty or any other drug activity, that is illegal. But they would not be able to find growers in Colorado when they passed this law in 2010 had they not allowed people that had felonies for cannabis. because that is where most of those growers came from, unfortunately. So that is the one exemption that they did put into there. Hopefully they do a similar thing in Florida, because as Mr. Wiley said, which I wholeheartedly support his position on, you know, if a state tries to convict to somebody and it's for cannabis, they should be pardoned. So they should not continue to have that conviction on their record. That's not the law today, but that's, you know, again, that's how 1284 is written in Colorado. I keep referring to that because that's the only thing that we really have, because there are no regulations in Florida.
There's nothing in Florida yet,
Right.
but that's an excellent question. Good job.
Very good.
Good job. Yeah.
In regards to starting a business, what is the status of House Bill 359 and Senate Bill 962, which, my understanding, is pre-written so that the Senate and the House can come back in special session after the amendment passes and pass it?
They could. There was a state senator was here that wrote that bill. He was here earlier, Senator Clemens. Yeah.
I'm sorry, I'm not speaking.
I mean, he didn't speak. He was just here. But yeah, he's already the framework's been written, and if they pass that bill, then that can establish exactly what the requirements are going to be, how many licenses are going to be put forth by the state. But you got to remember also, and the reason local council is so important is that there's certain cities and certain municipalities in the state of Florida that have already said that they're not going to allow any treatment centers in the city limits. I know Mount Dora has done that. Ormond Beach has done that.
Cocoa Beach as well.
Yeah. So there's going to be certain municipalities that are, no matter what the state says, they're not going to allow it. So, and then in other municipalities, they're going to put it off and they're going to zone it into certain places. And they could restrict the number of treatment centers per county as well.
Well, mine is, I'm wanting to be a grower, so.
You know, the way that that's all shaping up right now is, from what I understand, there's probably going to be 5 licenses given out and they're going to be placed in regions of the state for growing and distribution. That's. That is, but that's what they're already talking about for doing in Tallahassee for the medical marijuana as well.
So it'll be the same.
It could be. That's what they're talking about right now, and somebody else spoke about that earlier today as well. Oh no, you're fine.
Yeah. In the blue
Yeah.
shirt. If you can speak just a little louder into the, just get right up on there.
Oh, there you go.
Just like radio, get right up on there so we can hear you. Okay.
I would love to have my local law enforcement, my local elected official here to see this presentation. And what would you recommend as a resource, as an educational resource for us to carry back? Are you providing that? Is it something we can get to that? Or to have this information, that presentation, or a resource to get access to your knowledge, to carry that back to our local sheriff and our local elected officials?
Yes. Mr. Christensen actually, just the other day, spoke with another attorney down in South Florida, Michael Minardi, and you know, we're putting together a full letter that is going to be sent certified to each elected sheriff, as well as each office of the state attorney in Florida, putting them on formal notice that they have to sign for, that these are people's rights currently. What was an affirmative defense, since science has caught up, is now an absolute defense, and that interfering with anybody's right, in doing so, they will violate their they'll violate their right to immunity, so they can be stripped of their immunity for doing so. So we're trying to create this outreach. I can tell you that I have personally spoken to numerous elected officials, elected sheriffs, should I say. That's really where a lot of my work has come in. Ian Christensen has spoken to more of the political side of things. But in speaking to elected sheriffs, at first they're confused about this whole law. Most of them didn't even understand that it existed until we talked to them. I usually spend an hour or so. When they say they have 10 minutes, they're very intrigued and they hear it. And we've had numerous law enforcement, or elected sheriffs, should I say, who have stated the same thing, that after hearing all this, if they have a family member who's suffering, they're going to get them in contact with us.
So how can
The way to get the information is to visit our website. It's www.healthlaw.org. healthlawservices.org. On our website, we have all of that information detailed there. We also have it on our Facebook page. But in the next couple of days, the letter that's going to be going out to law enforcement is going to be available on our website for anybody to download. That does not a license to do it yourself. That is simply to provide to law enforcement to make them aware of the situation. Okay? You're very welcome.
Welcome.
Good stuff.
Amendment 2, it does say that we'll be able to cultivate. I heard you just say about 5 districts, but if Amendment 2 passes, even though California has 2 more years in, wouldn't that be as a patient, would we be able to cultivate because cultivating is to grow?
Through Amendment 2, there's no provision in Amendment 2 that allows personal cultivation.
That, if you read it, I think it's the second paragraph in the actual amendment, pages, it does say that we can dispense, cultivate, cook, it goes down, and cultivate is part of it. I didn't know, the definition of cultivate, I didn't
Right.
understand, as I'm thinking that meant grow.
No, there's no personal cultivation provision in Amendment 2. Yeah.
It's also important to know that Amendment 2 has not, well, based on the regulations of Senate Bill 1030, if they're going to be somewhat similar, which we shouldn't let the cat out of the bag here, but in order for a common law necessity defense to be abrogated, it has to be outlined in a specific statute that it has been abrogated. The Senate Bill 1030 says nothing about the or abrogation of the common law necessity. Now, if the regulations that are passed by the legislature abrogates that, then you absolutely would have no right to do that. If they do not put that language in the legislation, then that would not be abrogated whatsoever. You would fall under the statutes of common law rather than falling under the statutes created by Amendment 2.
All right, does anybody have any more questions for the panel? If you have any more questions, make your way to the mic. I have a quick question. I'd like to know, does anybody ever heard of the Cole memo, and what does that mean?
Okay, it's funny. I sent Lily a copy of the Cole memo on Thursday, I think. But basically, the U.S. Department of Justice has set forth certain guidelines, and that's all they are. It's not law. It's just policy right now, pretty much telling a properly licensed medical marijuana dispensary where they are legal that if you do the things outlined in this memo, then you're going to face criminal prosecution. And basically, it's if you're using it for tax evasion, if you're using your dispensary to sell other illicit drugs, if you're selling to minors, if you're selling the medical marijuana to try to take it to a state that doesn't allow it, if you're
Driving.
yeah, you have to try to prevent the use of the medical marijuana while operating a motor vehicle. Those are the things that if you avoid doing those things, then you're doing everything that the U.S. Department of Justice wants you to do, and they're not interested in you. It's very important to point out, however, that that is just policy, and that policy can be changed in 2 years when the current administration is no longer in. And we have a new president and a new head of the Department of Justice.
Allegedly not interested in you.
Right, yeah. Exactly.
Allegedly not interested.
So until marijuana and cannabis are removed from the Schedule I narcotics list on the federal level, you're still going to face criminal penalties on a federal level, if they want to. I mean, because they can come in and raid your shop, whether or not you're properly licensed in a state or not, right?
Yeah, and I think that's something that's also, I mean, we have to remember that the federal law is still something to be, something to be considered, and something that needs to be on everyone's mind, and everyone's has to comply. And, I hate to even bring up the synthetic industry because I know that's not what we want to talk about here, but however, what you saw happen in the synthetic industry is people were selling synthetic cannabinoids under the packaging that said not for human consumption. And what would happen is people were selling them, saying not for human consumption, thinking that they were getting around the regulations, and therefore they were all prosecuted under misbranding. And so similarly here is if you have I guess what I'm trying to say is that you can't use medical as a trump for the law, just saying I have the medical ability to cultivate this or have this, or my doctor says it's okay. This is a very specific area that you have to follow the law very, very closely and specifically. And if you toe the line and you go off of that line, you're going to be prosecuted. And that's something that needs to be considered.
Even the lawyers in that case, I think, got in trouble.
There were two prosecutors indicted. I mean, there was lawyers indicted in those cases as well.
For trying to help them get around the labeling, I think, of the product. You know, so that's why I have my lawyer here, and of course I had Tom give me a waiver of immunity before I got up here. So I don't know about you guys, but I have my get out of jail free card. I hope you do too. Does anybody? Oh, there's a gentleman here with a question. Go ahead, sir.
Mr. Jordan.
My name is Bob Jordan. I do have medical necessity patent, and I can grow cannabis legally. And my question, if you're a little confused because if you're saying you can prove medical necessity, okay, then you're okay. My question is, can with ALS, the ALS patients are pretty bad off. But anyhow, could I actually help another ALS patient?
Absolutely.
Or am I only down to one? I mean, you know what I mean?
There is no law that states that a caregiver can't act for more than one person. And as we referred, and your memorandum, as I said, you know, that was issued really gave us, that's really what's given us the energy this past year to move forward. So I thank you personally. But according to the state attorney's office, an individual who is cultivating for somebody with a condition maintains the same absolute defense. There is nothing that stated that you cannot do that for more than one individual as long as the other individual maintains that same absolute defense. If you, and the way I like to explain this for most people, and the only real way we could do this is by looking at other states and looking at the laws that they have currently, understanding Florida. You know, we have the same system of government that most other states have. In California, Proposition 215, when that passed, it is an affirmative defense. You are not required to register with the Department of Health. It is recommended that they do that and you get a red card, but it's not required. What has made the affirmative defense in California absolute is that science has caught up with the law. And in your circumstance, ALS, we know how it works. We know the neuroprotectant properties. We know what receptors it interacts with. So by having that documentation for each patient that's suffering from ALS, you can grow for anybody that you need to as long as you are following the guidelines for each specific person. Now, that's not giving legal advice up here. We're not doing that. We would say that, you know, to contact Mr. Minardi, we do work with him. You could speak with myself, Mr. Christensen, or Mr. Gearhart as well up here. And we would love to talk to you about that as well, because really, for right now, there are numerous other individuals that have not had the privilege of having the care that your wife has received from you. And they need it. And if you're the person that's willing to provide that care, the state cannot stop you from doing that. They can attempt, just like they can, that's why we have unlawful arrest. They can attempt, but they cannot prevent you from helping other people. In California, you cannot sell cannabis. You can receive donations for it. You can have a patient collective, have patients come in, bring medicine to you. You can distribute it to other people. You can do something to it and be reimbursed for your time, but you cannot sell cannabis. Florida is the same laws. We outline the elements that one needs to be met, or the courts have, meaning those exact three elements. Your memorandum from the state attorney's office is very important because you were the only individual that was named on that memorandum, meaning that you were a caregiver. They did not attempt to try to arrest or prosecute your wife because they knew the common law necessity abrogated, or the common law necessity applied to her. They tried this because they did not believe it applied to a caregiver. That memorandum outlined the fact that it did, and it is also because Kenneth Jenks was providing the medicine to his wife Barbara as well. So that is why the Jenks ruling is so important for patients and caregivers, because he was providing it for himself and for his wife. So based on their individual need, there is a way for you to do that, yes. And we'd recommend speaking with one of the attorneys to do that. But thank you.
Good question. Here's another one. You're up.
Sir?
If it's legal to, if it's not legal to cultivate, but it's legal to cultivate for a medical patient, that's what I'm completely confused on this right now. 'Cause
Can
it's
you
not
step a
legal
little
to
closer to the
cultivate under
microphone? We
Amendment
can't
2.
hear you.
Get right up on the
There
mic
you go.
there. Get right in there.
If it's not legal to cultivate under Amendment 2, how is it legal to cultivate?
There's no personal cultivation under Amendment 2. You would have to get everybody can't grow. Even if you have a medical card or a medical license that's issued by the Department of Health, after this passes, okay, you go get your recommendation from the doctor, you can't go home and start growing. You would have to get a license to grow, to cultivate, which they're not going to give to individuals. They're going to give to a company, and right now it looks like there's only going to be 5 of those companies.
So they can ensure there's testing.
Right.
And that's where I think a lot of people don't understand, and that's where attorneys are going to be a little more prevalent in this area.
Yeah, right now, there's no personal cultivation outlined in Amendment 2.
So the answer to your question, if it passes in November and you have a medical marijuana card, that does not mean you're going home and you're starting growing.
Right.
Is that everybody's consensus here?
that is
And I don't want to dilute the advice of the panel here, but let me just reiterate, a lot of this jazz, we don't know how this is going to play out.
Yeah.
So everybody up here is doing the very best on what we can't necessarily quantify. We can't tell you how to get around stuff that we don't know what the stuff is just yet. We can tell you what the law is and advise you on how to operate within the law. But like Lily said, we can't tell you how to beat something if we don't know what it is that we're beating because it hasn't been fully written yet.
Well, we can't tell you how to beat anything. What we can tell you is how to be within the law.
Yeah, how to
That's what we
comply
can tell
with the
you,
law.
is that if you're going to go see your attorney, how do I comply with the law?
Legal disclaimer, 2014. I get like that. This does not accurately reflect the advice and consent of 102.5 The Bone. I think the station makes me have, there's a disclaimer that goes real fast. It says, speed it up. Nobody can understand it. Yes, sir, what's your question?
How you doing? My mother suffers from
Get
glaucoma.
right, we can't hear you. Just
Sorry,
get right
my mother,
up in there.
My mother suffers from glaucoma. I was wondering if I became her power of attorney and started cultivating for her, is there a limit to exactly how much I will be able to cultivate?
The limit really is, there is no limit that's been set by the state of Florida. If you follow what Florida has allowed, there are 2 individuals, Elvie Musica and Irv Rosenfeld, that are mailed 300 marijuana cigarettes a month to the state of Florida. That is what's considered medically necessary for them. The only opinion that we have received, and again, it comes from a state attorney's office, this is not coming from a judge because there's been no precedent set, is whatever a physician states is reasonable, as long as it is backed up by scientific data, and that's another thing that we provide to you is all that data as well, then it has to be reasonable. If you're growing 500 plants because your mom has glaucoma, you're going to have some handcuffs and you're going to have a lot of explaining to do.
Now,
So-
if I was caregiver to several different patients versus just one,
then you would have to, based on the current law, you would have to have documentation with you, full documentation for every single individual that you're cultivating for. Now, mind you, that is an opinion from the state attorney's office. That is not a judicial decision. Another disclaimer there.
Right, that's kind of,
I would spend the money to hire the services of a lawyer on retainer so they can advise you on how to comply with the current present law. And then when that law changes in November, we assume, you then want to continue that relationship with a local attorney on how to comply with the new law and the new regulations. And the distinction is, Lily?
Well, I was just going to say also, you have to think about this, as I said before, you have to think about the human aspect of it, and you have to think about the common sense aspect. And if the officer comes and finds you with 25 plants and you're taking care of one person, the officer may say, I think this is excessive. I think that you have to think about those things as well. And maybe you can talk
Yeah,
a little bit more on that, but
It's a physician's recommendation. And just to kind of give a quick outline, I know we're getting a little off topic from the legal questions, but just a quick outline on that. If somebody is suffering, let's say, from chronic fatigue syndrome, where they have a broad spectrum disorder, Crohn's disease that's coming along, fibromyalgia, all these conditions, it requires the use of a cannabis oil. There are no facilities to go and purchase this oil currently, However, it takes 10 times the amount of cannabis to concentrate the oil. So if you have a statement from a physician saying that it's required to consume a gram of oil daily, then that is the equivalent, 1 gram is the equivalent to 10 grams of dry material. So it's really, that's why the physician is so important in this aspect. And we have been working with physicians throughout the state. There are numerous physicians now that are writing these documents for patients. And we are currently also working with other attorneys to make sure that there are numerous attorneys available to do this. Most attorneys have not had the privilege of taking a year off from work and just doing nothing but delving into this specific area that Mr. Christensen, Mr. Christensen has worked full-time in that process during that time. But that's really where it comes into, is it has to be reasonable. And if we educate educate law enforcement that consuming oil, which is really what they want, based on what most people that I've spoken to, they simply need to understand that it takes a lot more of the plant material to make this oil that is safe for, let's say, children, for a low THC. Children are not going to eat raw material, or they're not going to smoke something. So it takes a whole lot more for an epileptic patient using oil than it would for somebody that's smoking something for acute neuropathic pain. So it has to be justified. Very, very important. It has to be justified.
I think we have time for one more, if there's one more.
Oh, last question. Make it good. You're under a lot of pressure.
No pressure.
Hello. My question is, what is the process, or will there be a process for expunging people who have already been prosecuted and found guilty of marijuana use or are growing or whatever? Do you see that coming up because they're now going to make it legal?
I think your question, if we can't hear you all that well up here, is what do you do to seal or expunge your record? Is that what you're asking? Okay. The state of Florida, you get one seal or expunge your record, and one seal or expunge in your entire life. There's a difference between sealing and expunging. Expunging means that the entire file is pretty much shred, it's gone, it no longer exists. Sealed means it's still there, but the public can't have access to it. If you seal or expunge your record, there are 3 agencies that still have access to it. If you want to become a police officer, if you want to become a teacher, or if you want to become an attorney. Sealing or expunging doesn't make it go away. Okay, so just letting you know a little bit about it. I tell my clients that come in about seal or expunging their record, because you only get one in your entire life, and you have to have a withhold on that charge, and it has to be there are enumerated charges that cannot be sealed or expunged. So if you are at a point in your life where it's affecting your life, then yes, seal or expunge it. If you're at a point in your life where it's not affecting your life, you may want to consider whether you want to seal or expunge, because you only have that option once in your entire life in Florida. Does that answer your question?
Well,
What's the process?
Well, if now we're making it legal, and in the past it wasn't illegal, now it's more accepted, and well, you bought a joint when you're super young, but now you're in your 30s, and now you're looking into making an investment or owning one of these companies. Now the state realizes that it's not harmful anymore. How could that be used against you when now we realize it's a valuable thing?
Yeah.
It's not going to be a retroactive, so if you have a marijuana charge before it, the way I interpret it is you're still going to have the marijuana charge on your record. There's a difference between making it legal and make it legal for medical purposes as well, and also the weight amounts also. I mean, I think that what you have to look at is if it's on your record, it's probably going to stay on your record. It depends on what the charge is for. It depends on if there was an adjudication of guilt or not, on whether or not you can seal or expunge your record, and it also depends on if there were any other arrests or charges that went with it.
It's a great question, because we don't know how they're going to write that part of the law, so we can't tell you how to properly comply with that, because if there is a provision that says it's applied retroactively or ex post facto law or something that applies to your question, then we would be able to advise you on how to comply with it. But since we don't know if that language is going to be in there, which is a great point, if there's going to be a provision in the law that can be written by the legislature that was here, or some of the folks that's with the Senate or the House committee, that can address folks that have previous arrests, non-convictions or withholds of convictions, or convictions, that's something that they would have to add in, which is you did a great job as the last question quite frankly. I'm proud of you, because that is an issue that may preclude a large portion of the population, if they have convictions, from not owning a company in this process or this venture. So we can't advise you on that because it's not written, but it needs to be addressed in the writing.
Correct.
Would you guys agree?
Oh, absolutely.
So raise your right hand. We're going to appoint you as the new representative for this. We're going to send you to Tallahassee. I think he's got his hand up. It was great. It was excellent. It was a great question. Good job.
Thank you.
All right.
Pete, I just want to end with before Pete wraps it up. How many people here know who Al Capone is, or was?
Allegedly. Put your hands down. There's people here looking at you.
Back in the late 1920s and 1930s, we went through Prohibition, right? And Al Capone was one of the biggest bootleggers in this country. He did a lot of awful things. He committed a lot of different crimes. You know what he was ultimately arrested and convicted of? Tax evasion. Okay, one of the big provisions when running one of these companies, okay, is knowing what the proper tax laws are. And how many of you know that the only thing that a legitimate business properly licensed in a state that allows medical marijuana, what's the only thing that you can deduct on your taxes? Cost of goods sold. If you don't know that, and you're taking all of the other deductions that you think that any other business can, guess what? You might end up like Al Capone. And then the juice isn't worth the squeeze. Right?
That's right. That's right. And that's a great way to end. You scared everybody to death.
Absolutely.